Hey, it's your old buddy Brian Parker, attorney Brian Parker. We're getting back to the good stuff, meaning we're going to take a look at a lawsuit as opposed to the application of trial techniques or cheat sheets or anything else. We're back to doing videos for your use. This is a very popular one in that it is how to beat a Sallie Mae bank lawsuit. So when you hear Sallie Mae, you think, government loans, you really can't do anything, public loans. But tremendous amount of Sallie Mae loans are private debt. And what they really are just debt buyer lawsuits. In other words, they're 10 cents on the dollar, maybe, lawsuits, debts that anybody can beat if you just look at them the same way you look at the MCM or Crown Asset or PRA or UHG or Credit Corp. It's all the same crap, and I'm going to show you that. Remember that you can like, love, and subscribe this video, and I hope you do. And also comment. I guess someone said, how come you ever tell people to comment? So look down on the comment section, leave me a comment what we can do better, what we did that you liked and you want to see more of, or maybe have a video that you said, hey Parker, do that video. Usually I will do that. If you just saw that trial video I did, here you go, how to do a trial. A member called me and said, hey, I got a trial next week. I haven't a clue. I said, I do. So I put it down in a video and made a nice cheat sheet for her, and hopefully that's helpful. She commented and said, thank you. She's a very nice lady. So this is a pennies on the dollar lawsuit, okay? Just keep thinking of that. Here's a bill of sale that you will see in an education loan, all right? Get ready, because it's exactly like everything else you see with debt buys. Shazam, it's a bill of sale and assignment. It's the same terminology all debt buyers use. There's the typical forward flow language, Shazam. You can see right there, they say it's a sale and purchase agreement, and the whole thing is pursuant to the terms of the charge-off, educational loan portfolio purchase. It's a forward flow agreement, okay? They all debt buying lawsuits have forward flow agreements. They have the get out of jail language, Shazam, you can see right there, without recourse. That means, here, you take this piece of crap, and you can't sue us on it. Yeah, the brakes don't work, and we don't have to tell you that. You start driving, as long as it gets you there, just remember to hit a tree. You don't need brakes. But you can't sue us no matter what happens. It's as is. So when you see without recourse language, or in this case, without warranty of title and enforceability. Warranty of title is sort of a real estate term, and that means we are telling you we own it, but there's no real proof that we own it, and we're not gonna warranty it, meaning if something bad happens, you can't come back on us for title insurance. Think of title insurance. They're refusing to give title insurance. Well, if the person that's selling the debt says, you take this without recourse, and we're not even gonna guarantee the title, who do you think owns it? Well, nobody knows. So there's no real proof. Even the seller doesn't want anything to do with it. That's a hint and a half for you, okay? So, and usually there are no debts in a bill of sale. It's all accounts or portfolios. Let me Shazam. That's a little paragraph from the same bill of sale. You can see the words on the second line, without recourse. They're really serious. Please, without recourse. I remember this great movie. It was a John Grisham movie, and the new kid on the block was talking to the veteran, and they're talking about different kinds of cases, and the one attorney says, you gotta look out for fish files, and the young guy says, what's a fish file? He says, those are the cases that weren't good when they came in, and the longer they stick around your office, they're like fish. They get worse and worse of a bad smell. Well, this stuff is a real bad smelly fish, okay? You can look at other bill of sales from debt buying that are no bones about were debt buyer lawsuits. Shazam, that's a bill of sale from Lending Club to Galaxy International. In that first paragraph, they talk about the account purchase agreement on the second line, forward flow agreement. It's all debt buying stuff. An education private loan is sold as a owed debt. It's just the same terminology. Even the signatures are the same. Here's the signature of the bill of sale for Lending Club, Shazam. You can see it's Brandon Pace, Brandon Pace. There's several of those. I just gave you 3. That has a forward flow agreement. And the terms of the agreement is exactly the same as in that educational one I looked at. Shazam, hereby transfers, sells, conveys, and delivers to buyers successors and assigns without recourse. They don't want it. You take it. Here's another one. Bill of sale from Sherman originated to, Midland Funding. That's your old friend Midland Funding. Now they became Midland Credit. And that says the bill of sale and assignment is subject to the terms of the agreement, a forward flow, and is made without representations and warranties of any kind. That's the same language in that education loan. That education loan is from a case I'm doing against Southwood Financial Trust LLC. And I say it like that because they have different names. So I showed you the signature. Take a look at the signature on the case we're looking at today. Ready? Ready? All right, ready? Go. Shazam. Look at that mess. The first thing you need to think of is, where's the proof, A, that all my client's debt and account number and correct name went between all these entities? Secondly, who authorized those parties to sign so many of these things? On one page, by the way, it's a mess. It's probably a conglomeration of many pages, but if you are suing someone on something where the original creditor or some of the owners don't even want to give you a warranty of title, you're just throwing together total crap and hoping that the person you're suing falls in the 9 out of 10 club. What's the 9 out of 10 club? Statistically, 9 out of 10 lawsuits, collection lawsuits, are defaulted by some settlement, quick settlement with the law firm for fear, or just a default. So the 5 things that I want you to look at when you're looking at one of these Sallie Mae cases is the following. Shazam, your name and account number. Are they in the bill of sale and assignment? Nope. The stuff is sold without warranties or representations, or with your old friend as is language, without recourse. Again, you can't sue us is what that means for the piece of crap we're giving you. Hope you like the smell of fish. Number 3, there are no authorizations for the person signing all those documents. Okay, put it up again, that last conglomeration of Sallie Mae nonsense. Shazam. Look at that. There's no authorization for anybody to sign anything. There's one person has several jobs, wears several hats. You have to be authorized to do that, or it doesn't stand. Some of them aren't even dated. Think about that. Yeah, everything has to be dated to be correct and true. There are no assignments or proof of assignments between any of those 30 to 100 entities. An account, by the way, is not a debt. A debt is a debt, and it's defined specifically in the FDCPA. The word account isn't. But the debt has been placed in a student loan asset-backed security, or a slabs, the slabs trust. That's what those educational trusts are. They're slabs trusts. And until you see something assigning the debt out of the trust, it will continue to be just an account that a servicer is servicing. And in this case, we have Southwood Financial, which is known as a servicer in the student loan industry, claiming to be the trust manager. But there is no effort to show that the trust that is managing received the debt. So you have to look for that. So let's start looking at the loan real quick of the case we're doing today. It's a smart option student loan. If you've come to this video, you know what that is. Shazam. And that says at the very beginning of all of these, there will be the words lender. It'll show the lender, it'll show the location. The reason they do that, because the governing law provision, so when you sue someone on a breach of contract, you're saying you breached the contract, defendant. Well, you can't breach the contract when you're saying somebody else is breaching the contract. So the governing law says you must be sued in the home of the lender. In this case, let's put that up, the smart option and the governing law provision, Shazam. And there it says that you have to sue in the lender's home state. The state is Utah. I guarantee if you're reading this or watching this, you're in another state. So that's something for you to bring up. That's adding to the already smelly fish that you're dealing with. That's just more smell, okay? You're not in Utah. Why aren't you being covered by that and following the law of the contract that you're being accused of breaching? So I can't emphasize enough that these are placed in trusts. Let's look at that signature page again. Shazam. Those are all trusts of different iterations, and there's no proof that your debt is in any of them, half of them, two of them, one of them. Without that, they got no case against you. So they cannot prove the debt transferred between all those many entities. But in my case, South Financial is claiming to own the account, even though they're considered to be trust managers. So you recall I always refer to the linchpin of the video. There's of the lawsuit. Usually there's from 4 to 20 paragraphs. 1 or 2 are really, if you knock them out, you knock out the whole case. Here's my 2 linchpin videos. You should check those out to see what I'm talking about. And in paragraph 7 is what I bear in on the linchpin, and I hope it's helpful to you. Put up paragraph 7. So it's essentially saying my clients had a promissory note, and that's Exhibit A, and that was that smart option loan I showed you. And then they promised to repay the loan and it was made by Sallie Mae. Sallie Mae and Sallie Mae Bank are 2 different entities. They have a different corporate entity, names, code numbers, whatever you. So there's nothing in the complaint saying the word Sallie Mae really means Sallie Mae Bank. So it's probably the lawyer just took a Sallie Mae case and just threw it in there and didn't really care. But they're claiming it was subsequently assigned to plaintiff Southwood Financial LLC as a trust manager for Southwood Finance. That alone you can win just showing how messy that is. But while it may seem insignificant, don't throw away the fact that Sallie Mae and Sallie Mae Bank are different entities. I just Googled it. Let me put you up my Google search results. Shazam. Yes, Sallie Mae and Sallie Mae Bank are separate entities. And that goes into your counter affidavit. So the good thing for you is that Southwood is dependent, or your debt buyer that's saying they own the Sallie Mae debt is dependent on what they've said and the paperwork they were given, which is if someone is giving you paperwork and in the paperwork it says, we're not warranting the title, that this is what it is, and by the way, this is out without recourse, they're not giving these junk debt buyers, because that's what the Sallie Mae case is, the right stuff. They're hoping you default. Don't. Their name, by the way, is Southwood Financial LLC as a trust manager. That's what's on their complaint. Good luck proving that. So you've got to go in on everything you find. You remember I did 5 videos of about 8 minutes long analyzing the lawsuit and how to beat it. Let me just put those 5 up there. 2, 3, 4, 5. I always hope I'm pointing at them. And even the summons video has some nuggets in there that you can generate a defense. I made the point in that last video I did on trials. Every case where you are sued, a cause of action against you, if it's a breach of contract, it's composed of elements. If one of those elements is disproven or there is not proof for one of those 4 elements, you win. The burden of proof is on the plaintiff suing you. Here we don't even know who the real plaintiff is, and the stuff they are claiming to own and sue you on, their own previous predecessors and interests don't even want anything to do with it. So you're in good shape with one of these cases. So I would focus in on that trust manager name. It's all purposely unclear for 2 reasons. Number 1, it is unfortunately unclear in the people suing you, and it is purposely unclear because they can't, with good conscience, show you exactly what happened, because then you'd see that they don't own the right to sue you. They don't have standing. So you would go in your defense. Let's put this up for people. Shazam. You'll go in on the improper assignment. You talk about all those entities and where's the assignment and proof of authorization. Lack of standing. Without the proper assignment, chain of title. Without the perfection of said chain of title, they lack standing to sue you. You therefore then have violations of the FDCPA, mostly 1692E, If they put it on your credit, 1692E8. If they're claiming you owe something you don't, or an amount you don't, 1692EA1. Look up the Fair Debt Collection Practice Act. There's lots of good stuff there, strict violations, which these guys, the FDCPA regulates debt collectors, and they have a certain way of trying to get around things. Again, they're banking on the 9 out of 10 just defaulting, so they don't have to prove that much. I want to show you what is going to be on this video. So you'll go to killdebt.com to check this video out. If you want the word templates, I'll have an answer in this case that I did, a counter affidavit, and a securitization letter and a validation letter for you to send whoever your plaintiff is, and also all those predecessors and interests, send a letter to them. I've got it in Word for you. It's great stuff. And what happens is the right hand doesn't know what the left hand is doing, so if somebody's truthful, that screws up the lawsuit. If somebody refuses to answer, that can screw up the lawsuit. How come they have something, you don't? How come they're not? You can make a big mess and be a problem parker, as I always say. And then you'll have your show notes, my show notes, these things, which will help you explain if you don't feel like looking at this face again. But I hope you want to see that a Sallie Mae Bank student loan debt case is easy peasy. It's a debt buyer case. Even the creditor wants nothing to do with this. And you should want nothing to do with this either, in that you will just show the court, this is a fish file and it stinks to high heaven. Like, love, and subscribe, and give me your comments. If you want a video and I can do it, or I've done it, I'll do it for you. Just like this one today. Thank you very much.